the evening of October 13, 2023, a motor vehicle collision occurred when a driver named Simon Alexander Garza allegedly operated his vehicle at a high rate of speed, disregarded a red light, and collided with a Honda driven by 50-year-old Jose Fernandez. Sergeant Richard Morales from the San Antonio Police Department arrived at the scene, and the defendant was initially issued only a single traffic citation for driving with no insurance. However, the legal focus shifted over the following weeks after Mr. Fernandez succumbed to non-recoverable blunt force head injuries. And on November 10, 2023, investigators recovered a data recorder to confirm the extreme speeds by Mr. Garza. Armed with this objective evidence of alleged criminal recklessness combined with the victim's passing, law enforcement established the necessary probable cause to formally arrest Mr. Garza on charges of felony manslaughter. The defense alleges that the state's case contained a massive toxicological and medical blind spot. Pointing directly to the forensic findings, they argued that Mr. Fernandez was operating his vehicle with marijuana, cocaine, and alcohol active in his system, alongside an open container found right in his center console, all while simultaneously battling advanced stage 4 kidney cancer that had already metastasized to his brain. The case was heard in the 187th District Court of Bexar County, Texas, before Judge Stephanie Boyd, with a jury trial commencing on April 12, 2026. After the prosecution examined Sergeant Morales, defense attorney Marissa Giovenco initiated her cross-examination.
I'm sorry, one other thing on the crash report. You don't update any toxicology results on the deceased, correct?
If I had them, yes, and I request them, yes.
Okay, but we had toxicology in the medical records for Jose Fernandez, and you didn't update that on this crash report, correct?
They were not given to me, and I did not request for them or put a subpoena in for them.
Okay. What about an open container? Is that important to a crash?
It can be for if the officer observed it, they can put it, give the person a ticket.
Okay. But no one was given a ticket for having an open container in this incident.
I do not believe so.
But you're aware there was an open container in Jose Fernandez's vehicle, correct?
Again, I can't, like I said, that's the officer who wrote that. A container can also be bursted open by a crash.
Okay, that wasn't my question. You're aware there was an open container in Jose Fernandez's vehicle, correct?
I can't exactly say if it was open or not, because like I said, the video I see a container there, and again, I don't know if it was opened or crushed open by the crash.
And you actually went to the scene
That's correct.
and you saw Jose Fernandez's vehicle.
Yes, I saw the Honda. I observed a can in the vehicle. I did not pay attention if it was open or closed.
Don't you think that that's important to a crash investigation and whether someone is driving with an open container?
That's for the officer. If they observe it, it has to be observed by the officer.
Okay, can you listen to my question? Okay, don't you think it's important to note whether there was an open container in a vehicle when there's a crash?
Again, you
Yes
have
or
to
no?
have,
Yes or no?
it can be.
Okay. When would it not be important that someone is driving with an open container when they've been involved in a motor vehicle accident?
So whenever we're at the scene, somebody says, hey, the person smells like intoxicants, strong odor, go to the hospital. They say they have a strong odor, and that's significant.
Okay, and so driving with an open container, as long as you don't smell like alcohol, you're okay? It's not important?
Now, I think the traffic code says that if it's officer observed it, you give them a ticket.
Right. It's against law to drive with an open container, correct?
Okay, yes,
Okay. And drinking while driving impairs someone's driving, does it not?
it can, yes.
Okay. What about smoking marijuana before driving? That will impair your driving.
It could, yes.
What about doing cocaine prior to driving? That will affect your driving.
Yes, it could.
What about the combination of all three substances? That will affect someone's driving.
It could.
But that wasn't important to your investigation.
I didn't have any of those information with me.
But you had the open container, you saw it.
I can confirm that the driver was the one who consuming of any of that alcohol.
Sure. However, have you ever seen a open container in a center console and given the driver a ticket, even though there were other people in the vehicle?
That's correct. So I observed it. I can give that person a ticket. Again, the officer will have discretion to be able to give a ticket.
Okay. But you didn't observe the driver drinking, you just saw it in the center console and assumed it was theirs, correct?
I didn't observe that. Like I said, I observed the can. I didn't observe it was open to the point where somebody is maybe opening it to drink it.
Right, I'm talking about in the past. You said you have seen a open container in someone's center console and given the driver a ticket for an open container, even though there were other people in the vehicle, correct?
I'd have to go back and check my records. I don't actually think I've ever given that kind of ticket.
Okay,
Again, yes, that is the law. That is a state law.
okay. And so wouldn't you agree with me that it's due diligence for you to check a beer can to see if it's cold to the touch, if it's in the vehicle and someone was just in an automobile accident?
Again, I observed the can in there. That's all I had to do is be able to observe the can. It's on video and pictures.
Okay, let me ask my question again. Wouldn't you agree with me that it's due diligence for you to see if a can of beer in someone's vehicle after an automobile accident is cold to the touch?
Yes.
Okay, did you do that?
No,
And to your knowledge, did any officer at the scene do that?
I do not know that.
Did you question any of the occupants of Jose Fernandez's vehicle about the open container that was in their car?
I did not.
In your investigation, did you learn of any officer questioning anyone in the vehicle about an open container?
I did not.
Did you also have, is it your decision on what citations are issued?
It is not.
It is not. Okay. Are you aware that Simon was only issued a ticket for no insurance?
That was on the officer report, but I don't tell them to write that ticket.
Okay.
Ms. Giovenco cross-examined Sergeant Morales regarding the relevance of the open container found in Mr. Fernandez's vehicle, and the sergeant confirmed that he did not assign any importance to it during the investigation. Under Section 49.031(b) of the Texas Penal Code, a person commits an offense if they knowingly possess an open container in the passenger area of a motor vehicle located on a public highway, regardless of whether the vehicle is moving, stopped, or parked. Consequently, Mr. Fernandez was allegedly committing a misdemeanor at the time of the incident. Furthermore, under Texas Penal Code Section 49.04, a person commits an offense if they operate a motor vehicle in a public place while intoxicated. In this case, Mr. Fernandez's toxicology report directly establishes this statutory intoxication, proving he was operating the vehicle with a highly impairing combination of alcohol, marijuana, and cocaine in his system. By explicitly introducing Mr. Fernandez's toxicology report alongside this statutory framework, the defense's clear objective is to demonstrate that Mr. Garza was involved in an unavoidable accident, not a criminal act.
Okay. But probable cause. So if you have probable cause now for a manslaughter after Mr. Fernandez is passed, why wouldn't you have had probable cause for an aggravated assault at the scene?
The elements aren't there.
Okay, but the only difference is someone passed away, correct?
No, it's the speed of the vehicle and the disregarding the red light.
Okay. And you didn't know either of those factors at the scene of the crash?
That is correct.
Okay. And it took you a year and a half to find those, to learn that?
No, I think if I look at, can I look at the date? Yeah. So the vehicle speed was observed on 11/10 of 2023, which is a month, a little under a month.
Okay. And so at that point, you went and got a warrant?
The warrant is before that to get the ACM.
No, I'm talking about for my client.
I did not get a warrant.
Okay. Did you present the case to the district attorney's office?
I did.
When did you do that?
I look at my notes. There. Submission date shows November 24th of 2023.
Okay, November 24th, 2023. And you said, what was the date you said you learned of the speed?
It's November 10th.
Okay. And so without speed, you wouldn't have had enough that.
That is correct.
Okay. What's failure to maintain a proper lookout?
Proper lookout?
Mhm.
I'm not sure what you're referring to. Can you elaborate?
I mean, that's the question. What is there an offense for failing to maintain a proper lookout? Have you ever heard that before?
Like as if you're a lookout for a criminal act?
You know,
You're the lookout while somebody else is doing a criminal act?
It's a very good question. These are things the state is alleging. So have you ever heard of that? Is that an offense, a traffic offense that you've heard of? Failing to maintain a proper lookout?
You'd have to be more clear. Again, I don't really understand what you're asking.
Okay, there is not.
Taking one little piece out of there, but you have to explain what
Yeah.
what you're referring to.
Sure, there is not a traffic offense called failing to maintain a proper lookout, correct?
There's not a traffic offense. It's within a traffic offense.
Okay,
That's why I'm asking you to elaborate, because
within
it's within, it says within the traffic offense. It's not a specific traffic law violation.
okay, what traffic offense is it within?
Within, basically, for stopping at a yellow light, maintaining, observing traffic controls,
For stopping at a yellow light,
a red light.
at a red light? Okay, so speeding is what changed to you to give you probable cause for manslaughter, is what you're saying?
That is the element that I needed as well. Yes. Correct.
Okay.
With the red light.
Okay, and so if every person who speeds on the road committing an attempted manslaughter?
Unless they cause the death of another person while committing another violation. It has multiple violations while committing a death of another.
You requested the manner and death of from the medical examiner, correct? The cause and manner of death?
That's correct.
Did you review that?
I don't have it with me up here, but yes, I did.
Okay. You'd agree with me that the cause of death was blunt force injury related to renal carcinoma, correct?
Again, unless I see it in front of me, and
Okay, well, you can use your report to refresh your memory.
I need the autopsy report.
No, your report. You talk about it in your report. About second paragraph from the bottom, from the conclusion.
Yes.
Okay.
Ms. Giovenko questioned Sergeant Morales regarding whether simply running a red light and causing a roadside collision was sufficient to establish probable cause for a manslaughter charge. Under Texas Penal Code Section 19.04, manslaughter is defined as recklessly causing the death of an individual. Pursuant to Texas Penal Code 6.03c, recklessness requires the state to prove that the actor was aware of a substantial and unjustifiable risk but consciously chose to disregard it, a culpable mental state that requires significantly more than a standard traffic misadventure. When confronted with the medical examiner's official report stating that the cause of death involved blunt force trauma compounded by advanced renal carcinoma, Sergeant Morales did not disagree, but conceded he was unaware of the diagnosis during his investigation. Under Texas Penal Code Section 6.04a, a blunt force injury intertwined with renal carcinoma raises a complex issue of concurrent causation. While the statute dictates that a person is criminally responsible if the result would not have occurred but for their conduct, Ms. Giovenko seeks to exempt Mr. Garza from accountability for Mr. Fernandez's death. Instead, she emphasizes that the victim already had an advanced malignancy in his system, arguing that the pre-existing condition operated as a concurrent cause clearly sufficient to produce the death, rendering the defendant's conduct clearly insufficient to cause the fatality under the statutory exception.
And officer, I'm sorry, detective, the legal limit for your blood alcohol in driving is 0.08, correct?
That's correct.
Anything above a 0.08 would be an intoxicated driver.
Yes.
And that's only alcohol. Additional substances would definitely affect the level of intoxication.
Yes, we have to have the measurement of how much they have in the.
Okay. And officer, I'm sorry, detective, you went to the A's Up Sports Bar to collect the video that is still on the screen, correct, of the crash?
That is correct.
Okay. And you remember talking to the sweet old man who owns the bar?
The owner of the bar, that's correct.
Yes. Okay. You remember telling him that this is just an accident, it's nothing criminal?
I do not recall. Again, I can talk to them. A lot of people don't like to hear bad news, so I'm just basically creating a rapport.
So if you said that you were lying to him?
I'm just talking to him.
Okay. But do you remember telling him multiple times that this isn't anything criminal, it was just a crash?
Again, just building rapport with the person who's going to share video.
Okay, just a yes or no. Do you remember telling him, I want to say 3 or 4 times, that this is just an accident, it's not criminal?
Again, I didn't watch that in the video showing back there, so I'm guessing you saw it. I don't recall.
That's the answer. You don't remember saying that. Okay, so would reviewing that in your video help refresh your memory?
Sure.
Okay, officer, you watched your body cam now.
I'm sorry?
You watched your portion of the body cam now.
Yes.
Okay. And you recall stating that this isn't anything criminal, it's just a crash.
Yes.
After reviewing his body cam footage, Sergeant Morales confirmed that while securing evidence at the scene, he explicitly told Mr. Garza that the incident was nothing criminal. Under the Community Caretaking Doctrine and Texas Transportation Code, Section 550.022, a motor vehicle collision is initially treated as a routine traffic accident, centered on emergency response, public safety, and property damage assessment. However, the legal classification shifts from a civil traffic matter to a criminal investigation the moment law enforcement suspects that a driver was engaging in reckless driving. Because the incident was initially framed to scene witnesses as a regular accident, no criminal charges were pursued immediately. Nevertheless, the legal scope of the case shifted once officers obtained definitive knowledge of Mr. Garcia's excessive speed. However, while an indictment has been filed, the prosecution retains the absolute burden of proof pursuant to Texas Penal Code, Section 2.01, to establish every statutory element of this reckless conduct beyond a reasonable doubt at trial.
Very quick questions, Judge. Detective, in regards to that statement, do you recall when it was made?
You talking about the video,
The
the
date.
statement I made? Yes. Saw it on top of our camera. I believe it's the 24th.
Okay,
I remember it was after the crash when I was going to get the video.
okay.
Hang on. No, there's no time up there.
Was it, how about this? When was it in relation to when you got the report of the speed back?
It was prior to that.
So it was before you decided to file charges?
Correct.
Pass the witness.
In fact, you also stated that you can't take someone to jail for running a red light, right?
I didn't say that.
You didn't say that?
No.
And if speed was a factor to the crash, don't you think that that's a pertinent detail that you should update on the crash report?
No, again, I'm not going to change the officer's crash report and the speed because it wasn't relevant at the time the crash report was written.
Okay, but you testified that you're supplementing the crash report to add all of the pertinent details.
Can I look at, is there a block for the
Well,
speed?
just listen to my question. You testified that you supplement the crash report to add all of the pertinent details. Was that not the exact words that you said?
Okay, yeah, there is not a speed block to enter onto the crash report.
Officer, I'm sorry. Please just answer my question. Okay, I'm asking you. You testified that you supplement the crash report to add all of the pertinent details, correct?
That is correct.
Okay. Now, you're trying to tell the jury that there is not a portion for how fast the car was going. I understand that. Look at page 2. There is a spot that says contributing factors to the crash. Is there not?
Correct.
Okay. You did not supplement to add speed as a contributing factor to this crash.
Correct, because I put it on my.
I did not ask you why.
All right.
Thank you. And but you did testify that you would supplement to add all the pertinent details. And you can, there's no limit on how many times TxDOT will allow you to supplement a crash report, correct?
Correct.
You also did not supplement it to add any intoxication or narcotics usage to Mr. Fernandez.
Correct.
Pass the witness.
No further questions, Judge.
All right, is this witness excused or subject for recall?
He is excused by the state.
Subject to recall, Judge.
Ms. Javenko impeaches Sergeant Morales pursuant to Texas Rule of Evidence 613 regarding a critical omission from his supplemental paperwork concerning Mr. Fernandez's alleged speed and intoxication. When Sergeant Morales admits that the explicit purpose of a supplemental report is to memorialize all material investigative findings, Ms. Javenko demonstrates that his written documentation directly contradicts that standard. Under strict Texas Department of Transportation mandates, an investigating officer is required to formally denote the legal cause of a wreck within the dedicated contributing factors section of the CR3 crash report, an official legal document that serves as the definitive record of the scene. Instead of writing down Mr. Fernandez's alleged speed and intoxication, Sergeant Morales left this section blank. By conceding that he failed to supplement the document with these specifics, Sergeant Morales effectively admits to leaving the official record blank on the two essential elements of the state's criminal case. On April 17th, Mr. Garza was found not guilty by the jury verdict on the charges of manslaughter. Our next case occurred on January 5th, 2025. Defendant Sierra Ryan Robbins was arraigned in the 54 District Court in Lansing, Michigan, on a felony charge of carrying a concealed weapon under Michigan compiled laws 750.227. The charge stems from a December 12th, 2024 incident involving a solo vehicle crash at the intersection of South Pennsylvania Avenue and Alden Drive. Ms. Robbins, the driver involved in the collision, was alleged to have an illegal firearm in her possession after Lansing Police Department officer Elena Berquette responded to the accident scene and subsequently discovered the firearm within Ms. Robbins' vehicle. The defense contended that the search of the car was unlawful, and Ms. Robbins pleaded not guilty. A preliminary examination to determine whether probable cause existed for the charge was held in the 54A District Court in the courtroom of Judge Kristen Simmons. Prosecutor Abigail Wilson represented the state. Ms. Robbins was represented by attorney Luke Goodrich of the Ingham County Public Defender's Office.
This is a matter of the state of Michigan versus Sierra Ryan Robbins, 25-00116. Appearance, please.
Good afternoon, Your Honor. Abigail Wilson on behalf of the people.
And Attorney Luke Goodrich from the Public Defender's Office, here to represent Ms. Robbins, who is standing to my right.
Today was the date scheduled for preliminary examination on carrying a concealed weapon. Are we ready to proceed?
The people are ready, Your Honor. Thank you.
Yes, sir.
Any preliminary matters before we call witnesses?
Not from the people.
Not from the defense, sir.
You can call your first witness.
Thank you, Your Honor. The people call Officer Berquette.
You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under the penalty of perjury.
Yes, ma'am.
You can have a seat. You can state your first and last name and spell both.
Elena Berquette, ELANABURKETT.
You can proceed.
Thank you, Your Honor. Officer Berquette, where are you currently employed?
City of Lansing Police Department.
And what is your job title?
Police officer.
What are your general duties?
Respond to calls for service, self-initiated activity, and officer advising role.
How long have you been a police officer?
With Lansing, it'll be 2 years and 14 days. And overall, I think I've been licensed for about 3 years.
Okay. Now, were you working as a Lansing police officer on December 12th of 2024?
Yes.
And what was your assignment on that date?
Road patrol.
And were you in the area of South Pennsylvania Avenue and Alden Drive?
I got dispatched for a personal injury accident.
And what were you wearing while you were working that day?
Full uniform.
And does that have police on it?
It does.
And were you in a car, on foot, or something else?
I arrived in a fully marked patrol car.
And is that department issued?
Yes.
Now, on that December 12th date, you said you were dispatched for a personal injury accident, is that correct?
Yes.
And by that, do you mean a motor vehicle accident?
Yes.
Okay. Now, when you arrived at that location, what was happening?
There was a car in the northbound lanes of Penn, slightly in the road, that appeared to have collided with the curb and then a traffic closure.
And that location of South Penn and Alden Drive, is that in the city of Lansing?
Yes.
Ingham County?
Yes.
State of Michigan?
Yes.
Were you able to make contact with anybody involved in that accident?
Yes.
Who?
Sierra Robbins, the driver.
And do you see Sierra Robbins here in the courtroom?
I do.
Can you point her out and describe something she's wearing?
She is in the black knitted sweater.
Your Honor, I request that the record reflect that this witness has identified the defendant.
The objection.
No objection from the defense, Your Honor.
ID is noted.
Thank you, Your Honor. Now, when you made contact with Ms. Robbins, what was she doing?
She was in the back of the ambulance at that point.
And did you have an opportunity to speak with her?
I did.
What was that conversation?
I can talk to her about her employee notes for a little bit, got her license, and then we proceeded to talk about insurance.
And what happened when you started talking about insurance?
To my recollection, I began asking where it was at. She told me the glove box. To my, again, recollection, I said, do you mind? She was interrupted. She said, go ahead. I went into the glove box, and at that point, I found a firearm.
And do you remember what kind of firearm that was?
It was a revolver.
Do you recall if Ms. Robbins had a CPL?
She stated she did, and she did not.
Okay, can you describe that a little bit?
So I asked her, I said, hey, what's up with the firearm in the car? She said, oh, I have my CPL. Tried to confirm that she did not. And then she said, well, I carry under the certificate of completion, which is not by law a CPL.
Okay. And were you able to run a law enforcement check on her?
Yes.
Did it come back as her having a CPL?
She did not, no. I had Ingham County run that.
Okay. And did she acknowledge that the gun was in fact hers?
She said that her dad bought it for her under her dad's name.
But she knew that it was in the car, is that correct?
Yes.
Okay. I have nothing further at this time.
Cross-examination.
Officer Berquette testified that Ms. Robbins gave her permission to search for her license and insurance in her car. Under the precedent Schneckloth versus Bustamante in 1973, the Supreme Court ruled that for consent to be valid, it must be given voluntarily and not be the product of duress or coercion. So when an officer gets the consent of doing the search, the person cannot be pressed to comply with the officer's command. Here, Officer Berquette relied on her testimony that Ms. Robbins consented with the search for her insurance and license, but eventually found a weapon in the car. A concealed pistol license, known as CPL, is a confirmed document that a person has the legal authority from the state to carry a concealed pistol on their person or inside a vehicle, whereas a certificate of completion only proves a person has the educational training required to apply for that authority. And when someone in possession of a firearm doesn't have this authority, storing that weapon inside the passenger compartment of a vehicle is automatically classified as illegal concealment. In Ms. Robbins' case, her lack of the CPL is what gave the state the initial grounds to charge her. After Ms. Wilson finished her direct examination, Mr. Goodrich initiated his cross-examination.
Good afternoon, Officer Berquette. Did you do any type of work to prepare for this hearing today as far as reviewing materials?
I tried to, however, this was a last minute subpoena, so
Okay,
called
so
in day of.
did you have a chance to review your your police report?
The report, yes, body cam, no.
Okay, so not the body. So did you, and you recognize that this is the report that you wrote back on December the 12th?
Yep.
And when you do a police report, do you essentially kind of go off memory, or do you go by like the notes you take on scene, or how do you do that?
All of the above.
Okay. And do you remember specifically in this case, did you use all of the above?
Yep, I used my memory and the notes on scene. This report was written shortly after the accident was.
And Officer Berquette, when you were arriving on scene, did you turn your body cam video on that day?
I was running code there, and so with the way our cars are set up, it automatically turns our body camera on while we're running.
Okay, so your body cam was clearly running throughout this entire situation?
Yes.
Your Honor, at this time, I would like to show Officer Berquette a portion of her body cam video. I'm currently on Zoom to accomplish that.
Just for clarification, are we admitting this as an exhibit or for impeachment?
For impeachment. This
Okay,
time.
understood. Thank you.
And let me also just state that, so it is your testimony today that essentially Ms. Robbins gave you consent to search her glove box prior to you going into her car?
Yes, in the way I perceived it, yes.
Okay.
Around.
Okay, so I'm starting at about 1 minute and 40 seconds into this video. Does this appear when you arrive on scene?
Yes.
And is that, looks like the fire department's already there to assist the driver of the vehicle?
Yep.
And you were not called to the scene as part of like a criminal investigation?
No, no
right?
criminal investigation, no.
This is just an accident, somebody hit some ice or something like that, is it your report?
Yeah.
Go around. I don't think this is the one. Was there another vehicle involved in this?
No, she says she hit the ice back here, and obviously you can see she definitely came up through.
Is this her?
This is her here.
Let me grab your plate. Edward Tom Clean 98457 Ethan Oxford, Hope Creek.
Sounds like she's.
Officer, is it, after seeing this video, is it clear that you actually had contact with Ms. Robbins prior to her being in the ambulance on this occasion?
Yes.
On the car, Whitmer said she spun out, hit that pole.
I came like from back there. Why don't you get in our ambulance? I can check you out and I'll come to you in a second.
Okay, with you having seen now your first contact with Ms. Robbins, did she attempt to essentially tell you about the scene, about what happened with the car?
Yes, but I prioritized her injuries rather than a statement at that time.
Okay, so you sent her away to the ambulance,
Yes.
and so there's been no consent to search the vehicle at that point, having what you've seen there? An officer, is that you opening the car door, opening the glove box, and starting to pull materials out of the glove box?
Yes.
Huh? I'm sorry, what?
I was just seeing if it was in park.
Okay, and then officer, is that you proceeding to essentially kind of search through the center console of the vehicle at that time?
Yes, but not for any criminal reasons.
Mr. Goodrich impeached Officer Berquette by highlighting the stark contradiction between her testimonial and the record captured on her body-worn camera regarding the alleged consent to search Ms. Robbins' vehicle. Under Michigan Rule of Evidence 613, this constitutes a textbook impeachment by a prior inconsistent statement and extrinsic evidence. A lack of consent to search the vehicle constitutes an unreasonable and unlawful search under the Fourth Amendment. Because voluntary consent is one of the specific, narrow exceptions to the constitutional warrant requirement, conducting a physical search without it and without another immediate lawful justification renders the entire intrusion illegal. Mr. Goodrich's line of questioning appears to be a textbook execution of a defense strategy designed to dismantle the legal foundation of the state's case.
So you said not, you searched the console, you said?
Yes, I only search the places that are people most commonly hold their insurances.
Okay,
Okay.
okay, and that would be the moment that you found the firearm in the glove compartment?
Yes.
So after, I guess, seeing this video, is it now your testimony that you did not speak with Ms. Robbins at the ambulance prior to going into that car?
Correct. After seeing this video, it is refreshed, yes.
And it is also your testimony that you had no probable cause of a crime being committed on scene?
Objection, Your Honor, that is a legal conclusion.
Your Honor, I'm asking what her reasoning to search the vehicle.
No, she can make a determination as to whether or not there was probable cause to search.
It is our policy and procedure that whenever there's an accident, we get license, registration, proof of insurance. At this time,
The question is whether or not you have probable cause to search.
no,
And based on the video you've seen now, you did not receive any consent from the driver to search those areas of her vehicle, is that correct? And this video was a fair and accurate representation of what went on?
yes, this is what happened.
Can you just replay it, because I think maybe I missed something, unless you replay it, the portion that you originally played.
During cross-examination, Mr. Goodrich questioned Officer Berquette regarding whether she possessed the requisite probable cause to initiate a search of the vehicle. A constitutional threshold she ultimately conceded was not met. To satisfy this exception, a finding of probable cause within the context of a vehicular accident would require an officer to harbor a reasonable, articulable, and individualized belief that there was a fair probability the vehicle contained contraband or evidence of a crime, such as driver impairment or illegal weaponry. Under well-established Fourth Amendment jurisprudence, a motorist does not forfeit their reasonable expectation of privacy merely by virtue of experiencing a traffic mishap, nor does an accident grant law enforcement a blanket license to conduct a warrantless search of closed compartments. Because Officer Berquette was dispatched to a routine vehicle accident involving a car that had skidded on the ice, the scene was entirely devoid of any indicators of criminal activity, thereby rendering her subsequent intrusion into the glove box and center console an impermissible and unconstitutional exploratory search that failed to align with any recognized exception to the warrant requirement.
And are you aware of any requirements that individuals carry insurance when they're operating a vehicle?
Yes, it's law.
Okay. And you said, I believe on cross, that it's routine for your department to ask for that insurance. Is that correct?
Yes.
And was that your purpose in going into the car, was to confirm that there was in fact insurance?
Yes.
Okay, thank you.
My purpose was if she's being evaluated for an injury, there's a chance this vehicle is going to be towed.
Well, strike that. There's no question. You don't, but I have a question now.
Yes.
Because maybe I missed something. You testified on your direct that she gave you permission to go in the glove box. She told you that the insurance was there.
Yes, this was prior to being refreshed.
Okay, so the video we show is accurate, that she never told you that she had insurance in the glove box.
Correct.
And so you went and opened the door without her permission.
Correct.
And went in the glove box.
Correct.
And then went in the center console.
Correct.
No permission.
Correct.
No probable cause to search.
Correct.
Okay. Well, why are we still here?
If I could have a moment, Your Honor.
Thank you.
Thank you, Your Honor. Based on the testimony here today and the evidence, we are at this point not requesting bind over on this charge. Thank you.
Case is dismissed. You're all set. We'll get you a dismissal.
Thank you so much.
Judge Simmons found a lack of probable cause. According to the judge, the video explicitly showed that Ms. Robbins did not give consent for Officer Berquette to search the vehicle. As a result, the case was dismissed. These cases show how strongly the result of a criminal proceeding can depend on the thoroughness of an investigation and the truthfulness of law enforcement, and how far defense lawyers will go to expose severe investigative flaws when a routine civil response improperly shifts into a criminal inquiry. During their cross-examinations, defense counsel in both matters directed the judges' and jurors' attention to severe procedural oversights, flawed official reporting, and narrative inaccuracies in the officers' statements, highlighting the importance of anchoring a felony arrest to an undisputed factual basis rather than subjective assumptions. These included Sergeant Morales' poorly handled investigation and incomplete documentation, highlighted by his failure to verify an open container's temperature, secure a whole blood toxicology confirmation, or log these critical metrics into his official report, as well as Officer Berquette's untruthful line of questioning regarding if she asked permission to search Ms. Robbins' car. By pointing out these critical investigative omissions and the stark contradictions between the officer's claims and objective reality, the defense lawyers successfully proved that the state's accounts could not be relied upon. Comment below if there is a case that you would like us to cover. Thank you for watching, and don't forget to subscribe to see more case analysis.